Hi, folks. George Tate here, George Tate Law. Maybe you have questions about what premises liability is. I'll tell you what it is through a story. We had a client that came to us uh, complaining that she was at a hair salon and she fell on some hair. At the first take on that case, I thought, well, you're at a hair salon. Of course, there's hair, so you fell down on some hair. Big deal. Watch where you're going. It's not our fault that you fell down on some hair at a hair salon. But, these cases need to be investigated, and they need to be investigated fairly without any preconceived notions. So, we signed up the case, and I started to investigate the case. First of all, I looked at statutory law, ordinances, and so on and so forth. And as it turns out, the Salt Lake City Health Department has laws that says that hair has to be swept up between each and every haircut. In this case, the hair was not swept up between each and every haircut. There was excess hair on the floor. And if you know anything about hair on the floor, as my wife does because she's a hairstylist, who told me not to take this case in the beginning, but hair on a floor can be slippery, very slippery. So that was the first thing we found out, that there's an ordinance in Salt Lake City that says that hair has to be swept up between each and every haircut. Next, we had to find out if the hair was not swept up. So, what we did is that we sent a private investigator into this specific salon to see if they were doing what they were supposed to be doing. That is, sweeping up the hair between each and every haircut. What do you think? That's right. They were not sweeping up the hair between each and every haircut. So, that's what happened in this case. Hairdressers, hairstylists are supposed to sweep up the hair between haircuts. They didn't do it in this case. Still, you might think, well, hair on the floor, watch where you're going. In this specific case, our client sat down in the chair, and just before she sat down, she was recommended or talked into, if you will, to have a shampoo before she had her haircut. So she's escorted back. She has her, lays back in the sink there and has her hair washed. Now, our client, a fairly tall woman, and a diminutive or short hairstylist, finishes shampooing the hair, wraps a towel around her head, the client's head, holding on to the back, and it's dripping water running down her face, and towels drooping down over my client's eyes, and she's struggling to keep it up, and she's being guided to the chair, which is surrounded by hair. She can't really see it, slips on the hair, and severely fractures her foot, what is called a Les Frank fracture. The bones on the bottom of your foot were fractured severely. She had a long, complicated course. She had to have surgery on her foot. That got infected. All kinds of delays in healing. Rehabilitation was extended. Anyways, we finally settled that case. We settled that case, I want to say, for a neighborhood of around $200 and some odd thousand. Interesting thing about that case is the insurance company wanted to have a confidentiality clause so that we couldn't talk about it, but we done away with that because it wasn't negotiated for, and we settled the case. So, premises liability. There's a very high burden on property owners, especially when they hold out their businesses for business, for inviting customers in. They have to make sure that the premise is safe and free of hazards that go unseen, and that's called premises liability. So, if you have questions about that, feel free to give us a call. Take care. Bye.